Okay, so let's get started. Hello everybody. Welcome to the latest webinar, this one on the new appeal rights under the Homelessness Reduction Act. First of all, some housekeeping. So you will notice that your mics and your cameras are turned off. This is a default setting. If you have any questions, and we really hope that you do, or some contributions, things that you have seen happening in practice, please feel free to post a comment or ask a question in the chat or in the Q&A, and our speakers, Ben and David, will come to those at the end. So this webinar is being recorded, and afterwards will be available on the Doughty Street Chambers Housing Team webpage, along with the slides. So you'll be able to get those afterwards, and if there's anything that you miss, or if you have to finish early, you can catch up. So without further ado, I am delighted to hand over to the always impressive Ben Chataway and the font of housing knowledge, David Carter. Over to you, Ben.
Great. So the Homelessness Reduction Act has been around for a while, and we've probably all seen local housing authorities adopt it to differing degrees. We've seen PHPs, Personalised Housing Plans, etc. But my impression is that we're running really very similar kinds of case in the courts to the sorts of appeals and other cases that we were running before. So the point of this part of the seminar really is to begin to explore what sort of different kinds of case we could bring, or whether we can bring cases at a different stage to the stages that we've run in the past. So what's new? Well, basically we're going to start with reviews, because every review gives right to right of appeal if it's refused. And there are, broadly speaking, 4 or 5 different kinds of review that are now available. First is of a decision as to whether the prevention duty in section 195 or the relief duty in section 189B are owed. So in other words, right at the start of the case, there ought to be that decision as to whether an applicant is eligible and either homeless or threatened with homelessness. And at that point, if it's a negative decision, there's a right of review. Second one is about the reasonable steps. In other words, the reasonable steps that the local authority ought to be taking to help somebody secure housing. And that could be either under the prevention duty or the relief duty. And if there's a decision about that you don't like, right of review. Thirdly, the notice to bring the prevention duty or the relief duty to an end, usually after 56 days. Fourthly, decisions to impose a sort of sanction for a perceived failure on the part of the applicant to cooperate with the steps set out in their PHP. And then fifthly, query the right of review about referrals at the relief stage. Now, I'm going to mainly be speaking about the ones in bold, because I think they're probably the more pressing or practical ones. Just briefly before I do that, I'm going to say something about numbers 1 and 4. First off, the prevention or relief duty. There ought to be that section 184 decision issued pretty early on in an application now, that simply deals with eligibility and homelessness, not priority need, not intentionality. And I mean, I have quite often seen local authorities really skipping that whole stage, or trying to, and issuing an old style section 184 decision that deals with all the usual 4 issues together. But that really ought not to be happening. There ought to be that decision towards the start of the case. And if that's something that other people have seen a lot of too, perhaps put a note in the chat, and we'll come to that. Maybe talk about it a bit more later. The fourth one on the list is about this refusal to cooperate. And as you probably know, the new provisions in the Act have got quite detailed rules about the process that local authorities have to go through if they're going to impose a sanction for failure to cooperate. They are detailed. I mean, I haven't seen a lot of those decisions issued. And I think it's partly because local authorities are doing so little to implement the prevention or relief stage. They're not that bothered about bringing those duties to an end. But if other people have had a different experience, again, we'd be interested to know about that. So put something in the chat. But first off, number 5, referrals. Why is there a question mark over this? So we'll all, I think, be familiar with referrals based on local connection. And, we'll have all seen in the past cases where the authority accept that a person is eligible, homeless, priority need, not intentionally homeless, so that a Section 193 duty would be owed, but they seek to avoid it by referring the applicant to another authority based on local connection. And as you'll know, there are 2 stages at which you can request a review. The first stage is where the authority make a decision to notify the other authority that they think the conditions for referral are met. And then the second stage is the joint decision as to whether the conditions actually are met. And at both stages, there's been a right of review and appeal. So what's new? Well, the Act now permits referral at a much earlier stage. So if an authority find that somebody is homeless and eligible, such that a relief duty would be owed, but they think they've got a local connection elsewhere and no local connection in their own area, they can notify of an intended referral at that point. So it's a much earlier stage, even before the applicant knows whether they are accepted as being in priority need, for example. And so they can say, that stage, off you go. You should be basically applying somewhere else. And that new power is in Section 198 open brackets 1A. So there are 2 potential referrals now in Section 198. The old style one, Section 193 stage, that's in subparagraph 1, and the new style one at the relief stage, and that's in subparagraph 1A. The issue is that when you look at the Section 202, it only provides a right of review for the old style decision to notify. It only refers to Section 198(1), not 1A. And that's why the code of guidance says quite clearly applicants cannot request a review of the earlier referral. So that seems pretty clear. Why is there an issue about it? Well, that's not the whole story. First off, the way that the referral works is that just as with Section 193, if the authority notify the other authority that it intends to refer, then that stops the relief duty being owed. So in other words, it's in effect, a decision to refer is a decision that no relief duty is owed. And so therefore it's arguable that under Section 202(1)(b), it amounts to any decision as to what duty is owed, because it's a decision that you're not owed the relief duty because we can refer you elsewhere. That might seem a bit of a stretch, but then things get even muddier when you look at Section 184, because it specifically talks about the 198 open brackets A1 decision. That's the decision to refer at relief stage. And it says quite clearly, the authority's got to notify the applicant of that decision, and the notice shall inform the applicant of his right to request a review, which according to the Code of Guidance, he doesn't have. So that's why there's some uncertainty about it. And it's an issue that, in my view, is waiting for somebody to bring up and to JR an authority when you request a review of the referral, decision to notify, and they refuse. So what about the other cases that you can, the other types of decision where you can ask for a review? Well, I think one of the main ones is going to be this one. Any decision of a local housing authority as to the steps they are to take to help somebody secure housing under either the prevention duty or the relief duty. And often that decision will be communicated or set out in the personalised housing plan, because the plan is supposed to say what steps the local or housing authority will take and what steps it expects the applicant to take. But that's not always the case, because you might have a decision to refuse to take a step, and that's not going to be in the PHP necessarily, but there's still a right of review whenever a decision like that is made. And just a reference here to section 189A9, which is the duty to keep the assessment and in effect the personalised housing plan under review. So supposing somebody's applied for housing, a PHP is issued, they don't challenge it, and then maybe they miss their deadline for requesting a review. And 4 weeks later, they come back to the authority and say, well, look, I still can't find housing. I want you to do this for me. That might be a gateway to prompting a new decision that is then reviewable if the local authority refuse. What's the process? So just as we're used to, request has to be made within 21 days of notification of the decision. There won't necessarily be a decision letter. I mean, you might have a local housing authority simply refusing to do something that you've asked them to do. But if it's clear that there is a decision, whether or not it's in a decision letter, you can ask for your review at that point. What happens next? Well, we're used to this. Reg 5 letter goes out. This is from the review procedure regulations, inviting representations. And then Reg 7 applies. So the reviewing officer is supposed to consider it, maybe issue a minded to letter. But then things get different. Instead of 8 weeks for the completion of the review, the decision ought to be made within 3 weeks. But 3 weeks of the request or 3 weeks of the date of any representations under Regulation 7. And it's not entirely clear what does that mean. Does that mean that whenever you put in representations, it starts the 3-week clock running? Or does it only mean whenever you put in regulations under 7.2, when the local authority is issued a minded to letter? Probably, I think it might be the former. But so it's 3 weeks, a bridge deadline, but subject to this proviso that the clock is reset when you make reps. And then, as usual, you've got your 21 days to appeal if you take issue with the review decision. So what sort of things might we be arguing about? Well, it's important to remember what the duty is, and it's similar, or substantially the same, for both the prevention duty and the relief duty. Is a duty to take reasonable steps to help the applicant to secure that suitable accommodation becomes available. And a couple of things to say about that. I mean, steps must mean doing something, I think. And there's steps to help somebody secure accommodation. So, I mean, arguably, this ought to be more than the bare duty to give advice on homelessness under section 179 that applies to everybody, because prevention relief duty are more specific than that. And importantly, what both duties, both sections say, is that the authority must have regard to their section 189A assessment. And of course, that assessment ought to set out the cause of the applicant's homelessness. It ought to deal with suitability and housing need, and it ought to look at the support that they need to obtain and keep accommodation. And there's a reference there to, I think, the only reported decision based on the reasonable steps duty, a case of Lindsay Johnson from Chambers XY and Haringey, where it was said that the assessment really ought to set out the nuts and bolts for any offer of accommodation. And in that case, you had a vulnerable young woman who's a victim of trafficking. And it was held that the assessment, or at least some of the assessments, hadn't done enough to really identify suitability in her housing needs. So that's the core of the duty. There isn't, of course, a right to review the assessment. So you can't just say, well, we disagree about your judgments on suitability. You've got to frame it as a decision about the steps to be taken. So if, for example, the authority assess you as requiring accommodation anywhere, could be Midlands or wherever, that isn't in itself reviewable. But if they say, here are the steps that we're going to take, we're going to give you a list of agents in the Midlands, for example, then that is reviewable. And so you've got to be wary to frame the review request in that way. So what other kinds of issues might arise? Well, there are, I'm going to flick through all of these. Yeah, I think the first one is about whether the steps ought to include the provision of accommodation, because there's no doubt that the relief duty can extend to the provision of accommodation. And that's spelt out in section 205.3, which makes it clear that if you're going to do that as an authority, you've got to comply with the suitability requirements, section 206, you've got to comply with section 208 about out of district placement. And the code gives some helpful examples of the sorts of case where the local authority ought to be thinking about whether to do that. For example, where the applicant is a young person with a low income who's unlikely to find or be able to afford the housing that they need in the private sector, or people with an offending history, or people with a mental health problem. And also it talks about rough sleepers who are at risk of harm and need emergency accommodation. And obviously in times of COVID, that puts a whole new complexion on that. But also I think we're worth remembering the earlier guidance, those are both in the current code, but looking back at the 2012 supplementary guidance that dealt with the Localism Act changes, made the point that local authorities can't assume everybody's suitable for private rented sector offers or private rented accommodation discharge. And in the same way, it seems to me that there are arguably some applicants where the plan ought to be that they're provided with temporary accommodation while they are given an opportunity to apply under Part 6 for social housing. And if you think those are the steps that the local authority ought to be taking and they disagree, then at the relief stage or even the prevention stage, you could launch your review. What about other issues? The code makes it clear that the assessment ought to deal with a whole range of things, size and type and location of the housing that's required. So what about type? I mean, supposing you've got a young person who is going to be limited in what they can claim for housing benefit or universal credit to the shared room or the shared accommodation rate, so not a self-contained flat. And for some reason, be it mental health problems or whatever, you feel that that wouldn't be suitable, then it seems to me that's likely to give rise to a situation where the authorities say, here's your plan, shared accommodation, that's what we're going to help you find. And if you disagree, you ought to be launching the review. And a location, I mean, this is the example that we touched on before. Out of area placements, we all know what it's like to have somebody who's confronted with the offer of uprooting a situation where they're required to uproot their kids, accept accommodation many miles away. And even if you think that it's arguable that that's challengeable, you're having to advise them to accept it and move and request a review because that's their only sensible choice. If you can raise that issue earlier in a whole process during the prevention or the relief stage, when the PHP is being formulated, then it seems to me that may help to avoid that situation, because you can row about the location, you can launch your review, and if necessary, your appeal at a much earlier stage before the offer is made. And that's got to be in many clients' interest. And then lastly, it needn't be about the accommodation at all. It may be that you're saying to the authority, it's about the support they ought to give, whether it's providing a deposit or providing practical help to look for accommodation, or any other kind of support that might be necessary. And it's just worth flagging up that the Code of Guidance has got quite detailed provisions in it about particular groups of applicant and the sorts of help that they might need. And there's just a list of them there in the various chapters in the Code of Guidance that apply. So what about moving on? What about the other sorts of thing? The notice to end the prevention or the relief duty. Well, it's important to realise that in these sort of termination cases, there are going to be two elements really that might be an issue. One is about whether the conditions for bringing the duty to an end have been met. But even if they are, usually it's a discretion that the authority has to bring the duty to an end. And so it's not that there are both bits that the authority ought to be addressing. And with the conditions, you need to look pretty carefully at the conditions that the local authority are relying upon. And they're listed there in section 189B7 for the relief duty and 1958 for the prevention duty. And I'm just going to pick on one example, which I think is probably at the moment the one that's being used most often, which is the authority says, well, we're going to terminate the duty now because we've complied with it for 56 days. And even though you haven't got yourself accommodation, we've done our bit, and that's enough, and we're going to bring the duty to an end. And I just want to flag up, I think, three things about that sort of scenario. The first is that the condition is that the authority has complied with the duty to take reasonable steps, which it seems to me is a different thing from saying that they have complied with the Personalised Housing Plan. And that is because whatever is written in your PHP, it seems to me it ought to be open to you to argue that the authority hasn't complied with its duty if the PHP wasn't good enough. And even though you didn't challenge it at the time, there are other reasonable steps that you think the authority ought to have taken. And I've put some references there to some bits of the code that I think help to support that distinction. I'm not going to read them out now because we're pressed for time, but they're worth having a look at if you're faced with that sort of situation. Secondly, compliance with the duty must, I think, assume that there has been a proper assessment of housing need in the first place. And if you can say that the assessment was inadequate, then you might be able to argue that there wasn't, therefore, adequate compliance with the duty to take reasonable steps. And I put there another case of Lindsay Johnson's, not about the new duties, but about the old limited power under Section 192 to provide support for people who, an applicant who had no priority need, where the discretion is supposed to be based on an assessment of housing need, and that's got some helpful comments in there about the need for an assessment to base a lawful decision. And then lastly, compliance, one-off compliance is not enough. Compliance ought to, it seems to me, to be compliance across the whole period of the 56 days, if the local authority are truly to say, lawfully to say at the end of it, we've done our bit. And again, there's some hopeful stuff in that, in the code of guidance about that. And I said, that's the first bit. That's whether the conditions for termination are met. The second stage is that even if the conditions are met, all that the two duties of Section 189B and 195 say is the authority may give notice to bring those duties to an end. It doesn't have to. And in particular, if you're looking at the 56-day duty, the code is quite clear in saying authorities shouldn't have a blanket policy of ending the prevention or relief duties after 56 days. They can allow more time and carry on helping. And, in times of COVID, it seems to me there's a strong argument for saying that authorities really ought to be extending the time over which they help. Lastly, just about the process, here it's the usual rule that applies. If you're arguing against a decision to bring the duty to an end, then it's the old-fashioned 8-week period for review that applies. So that's all about the reviews. What about the appeals? What sort of arguments you can be able to raise? Because of course, these are duties, but they're only duties to take reasonable steps. So there's a huge area of judgment involved, and we're going to be limited to public law challenges. What sorts of challenge might we bring on a Section 204 appeal? Well, you might have an argument about misdirection. And going back to that example, which I think is I've got from a case that Sarah's dealing with, the distinction between the conditions for termination involving compliance with the duty to take reasonable steps rather than a duty to simply do what's in the PHP. And if the review officer turns around and says, no, I'm satisfied, we've done exactly what was in the PHP, and ignores a wider issue about reasonable steps, that might be a misdirection in law, for example. Or you might find that the complicated conditions for termination aren't met in some other respect. And then I think the obvious one for clients who've got a possible potential disability is Equality Act stuff, PSED, but also claims for discrimination. And if you think that the authority, its ways of operating involve a policy, a criterion or practice that puts disabled people at a disadvantage, or there ought to be the subject of a reasonable adjustment, then that's the sort of issue we ought to be raising. You'll probably know there's a case at Adisotu where it was held that if you're going to appeal under 204, you can't just bring a generalized complaint of discrimination. You've got to focus on the decision, the review decision. So if you're going to raise arguments about discrimination, you've got to raise them in the course of the review to get the review officer to address them, and then unpick or challenge his response to them. But there's a lot of scope for, I think, bringing those in. Section 11 Children Act, again, you'll know it in Zola Meso. Those sorts of things might be applied. And also any other relevant considerations. So, there's a lot in the Code of Guidance about what the relief and prevention duty should involve. has the authority really had regard to that? And obviously, it seems to me in the current climate, there's COVID, which remarkably, local housing authorities seem to just overlook entirely when they're issuing decision letters, whether it's about relief duty, prevention duty, or anything else. So there, I think, just some ideas at the sorts of challenge that we ought to be looking at, and what's different under the Act. Very quick word about legal aid at the end of it. Basically, there's not an issue, it seems to me, with legal aid, because it's plainly in scope. You don't have to be arguing about the provision of accommodation. You can be arguing about the provision of assistance under Part 7, which it seems to me would cover almost anything you need it to cover. And then the usual criteria apply to a Section 204 appeal in the old style cases. So you've got to show you've exhausted all reasonable alternatives, and you've got to show the proportionality test is met. So it's got to make some difference. But basically, I think legal aid ought not to be an issue. That enough from me. If you've got specific questions, please do post them in the question and answer section. But otherwise, I'm going to hand over to David. And David, I think you're muted.
Good afternoon, everyone. I should say that I'm not in control of the slides. That's Ben's province. So rather like when you get out of sync when you're watching someone on television, there's a possibility that may arise in this case. Ben, can we move on to the first slide? I'm going to be talking to you about interim accommodation. There have been some significant changes to the duty to provide interim accommodation, which came about as a result of the Homelessness Reduction Act. As Ben said, it's nearly 2 years now since the Act came into force. And we thought it was sensible to revisit not only the topics that Ben's been talking about, but also the changes to interim accommodation, because it's a discrete package. There are, whenever somebody applies to a local authority, there is always an issue about whether they can be housed pending the determination of that application. There are two questions which arise. One, does the duty to secure accommodation come up in respect of that particular applicant? And secondly, when does that duty come to an end? Now, Section 1881 and its predecessors in the previous two acts dealing with homelessness the duty has been identical. It hasn't been changed since it came into force in July 1977. But the Homelessness Reduction Act has changed when the duty to secure accommodation under 188 ends. So I'll be looking at that in a moment, but just a quick reminder, the current position is that there is a duty to secure accommodation under Section 1881, given certain criteria being satisfied. The duty ends and a power arises if the applicant seeks a review of the decision in question, and it is a reviewable decision. And there is further a power to secure accommodation pending appeal if the applicant appeals to the county court against the particular decision. Now, as Ben's been at pains to point out, one of the effects of the HRA is to extend the number of decisions that can be subject to appeal. In the good old days before 3rd of April 2018, a Section 184 decision meant that the local authority's determination of the application, full stop. That's been complicated now because there is not just one decision that the authority can make, which counts as a 184 decision. And what we're going to look at is when in certain circumstances when the 188 duty came to an end. Can we move to the next slide, Ben? First of all, this is unchanged, but it's worth revisiting. When does the duty arise? Well, I've highlighted here must, have reason to believe, and may. Click one more, Ben. I think it's probably, and the next one, and the next one. So the authority has a duty to secure interim accommodation, but what triggers that duty is a low threshold. The law's got lots of different words to describe when legal powers or duties come around. About the lowest end of the duty is have reason to believe. So the applicant may be telling them a pack of lies, but if it's sufficient to give the authority reason to believe, then the duty will kick in. And it isn't even a reason to believe that somebody is eligible homeless and has a priority, merely that they may be. Let's move to the next one. So the fact on the words of the statute suggest it's a low threshold. That is reinforced by the Code of Guidance. Paragraph 15.5 says this: the threshold for triggering the Section 188(1) duty is low, as the housing authority only have to have reason to believe, rather than being satisfied, that the applicant may be homeless, eligible for assistance, and have a priority need. And in addition, if you can click the next one, Ben, there's case law. Lady Hale, just one of several judges who pointed out how low the duty is. In another case, Robinson, Mr. Justice Collins said, really, in the vast majority of cases, an applicant has just got to say that they're aged between 16 and 18, and you will have reason to believe that they may have a priority need, unless that is quite clearly a lie. So the duty kicks in at a pretty low threshold stage. Can we go to the next slide? I put this in because this is something which always crops up with authorities, particularly in relation to the acceptance of applications and the acceptance of a duty to secure interim accommodation. There are changes under the HRA to the local connection provisions, and Ben highlighted one of them in his talk. There has been no change. Local connection continues to be irrelevant. So it is remains the position that an applicant can apply to any authority, regardless of the local connection. That authority cannot turn him or her away because they have never lived in the area or have any other connection with it. And in addition, the authority cannot impose conditions on the existence of the duty. And there's a reference on the slide to Kelly against Birmingham, not reported, but you can get the case transcript of the usual sources. In that case, the local authority, Birmingham City Council, refused to provide accommodation because they said that although they had reason to believe the applicant who had a priority may have had a priority need and may have been eligible, the fact that he had some sort of accommodation was relieve them of the duty to provide interim accommodation, and they could only be required to do so if there was a risk of harm at his current accommodation. The High Court rejected that defence. So local connection is irrelevant, and additional criteria cannot be imposed by the authority. Next slide, please, Ben. I thought this was worth raising. Brooks and Islington case 4 years ago, just over 4 years ago. In this case, the court distinguished between the ending of the duty and the performance of that duty. So this was a case decided before the Homelessness Reduction Act amendments came into play. Miss Brooks applied to Islington. She had at least one child and therefore had an apparent priority need. There was no issue relating to eligibility, and she appeared to be homeless. So Islington, having accepted an application, offered her accommodation. It was, however, accommodation outside of Islington. She was local to Islington. And as sadly too often happens, she refused the offer because it was too far away. I have to say, it wasn't points north of Watford. It was in, I think, Waltham Forest, or one of the outer London boroughs. And she refused that offer. Now, suitability is an issue for the authority, as it is in relation to any accommodation secured by a local authority. And Islington decided that it was suitable, taking into account what she had said. And bear in mind that the test for suitability is a pretty low one as far as the authority is concerned in relation to interim accommodation, because courts expect applicants to put up with more, if I can put it pejoratively, if it's only likely to be a relative for a relatively short time. So in her judicial review, her argument was, well, the Act, section 1881, requires you, local authority, to provide me with interim accommodation pending the determination of my application, because that's what the section 188 said at the time. And it didn't go beyond the High Court, and the judge said that the duty did indeed continue until such time as the authority had given its 184 decision. But they were relieved of performing that duty by her refusal to accept a suitable accommodation, and there was no challenge to the suitability decision. So there is a difference between the duty coming to an end and the authority being relieved of having to perform that duty. Next slide, please, Ben. So that begs the question, when does the duty come to an end? And this is where the HRA does change the position. As I said, before the changes, it came to an end when the 184 decision was given. And the 184 decision would have been before the changes, but no duty was owed because the applicant was not homeless. That an advice and assistance duty was owed because the applicant was homeless but didn't have a priority need. And if the applicant was homeless and had a priority need, then the duty would be either to provide accommodation for a short period and give advice and assistance in the case of the person being intentionally homeless. But if that person was not intentionally homeless, then of course it would be to be owed the full duty. So that was the decision that would have come about. Now, though, the effect of the HRA is to make it more complicated, so that the duty ends at a different time depending upon the decision made by the local authority. Next slide, please, Ben. And the next one. So the first point to make is where there is no priority need. So if the authority has decided that they do not owe a relief duty and the applicant does not have a priority need, in those circumstances, the duty ends when the authority notify the applicant of that decision. Now remember that the relief duty is owed if someone is eligible and homeless. So this envisages a circumstance where the applicant is either not homeless and eligible and not in priority need, or homeless and not eligible and not in priority need. In those circumstances, subsection 1ZA says the duty ends when that decision is notified to the applicant. So there has to be a proper notification letter. Next slide, please, Ben. So again, we're dealing here with a case where the authority has decided that the applicant has no priority need. So if the decision is there's no priority need, but a relief duty is owed, so pausing there, that means that the findings are that the applicant is eligible, the applicant is homeless, but does not have a priority need. So in those circumstances, the duty ends when the authority notify the applicant of the decision. But when the relief duty ends, because as Ben alluded to, it will end in a number of circumstances, but commonly after 56 days, they don't owe the applicant any duty under section 190 and 193. And just to recall, section 190 is the duty owed to someone who is eligible, homeless, has a priority need, and has become homeless intentionally. And section 193 is the full duty. Now, there's only one case that I can locate, a reported case on this, and that's Mitchell against Islington again. And in that case, Islington sent out a rather anodyne standard letter, and they merely to notify the applicant they no longer owed a section 188 duty, and they did not distinguish between what I've termed priority need 1 and no priority need 1 and no priority need 2. So they didn't say whether the applicant was not owed a relief duty at all, or was owed a relief duty which had come to an end. The court said it's essential that the authority sets out in the notification which of those options applies. And of course, the effect is that if you don't notify properly, then the interim duty has not come to an end. Next slide, please, Ben. So those are the two options where there's no priority need. In any other case, the interim duty ends on the later date of one of two events. At the end of the relief duty, or when the authority notifies the applicant that they don't owe a relief duty, or when the authority notifies the applicant as to what other duty, that's a duty other than the relief duty, though they owe the applicant under Part 7. Now, I have to say I haven't as yet. I have not been asked to advise on either of these positions. I suspect, being somewhat cynical, that it's that the local authority really doesn't give it much thought. I should also say it's not without its difficulties, and it is somewhat complicated. And I have some sympathy for local authority officers trying to tease out when they have to give the notice and what notice they have to give. And it may be that authorities are erring on the side of caution, but it certainly is bound to happen at some stage, and it did happen in Mitchell, that the authority is going to get it wrong. So you need to be aware of it. Next slide, please. Now, so the first major change is the date at which the duty has come to an end is no longer the same for all decisions. The second change is the clear distinction between the duty to secure interim accommodation under section 1881 and the power to provide interim accommodation pending review, that clear distinction has been breached in a limited way. And that is, if the applicant has asked for a review of the authority's decision on suitability of accommodation which has been provided, but only accommodation provided by way of a final offer or a final Part 6 offer. So that's, you'll have to look at section 193 for that. Then the relief duty is not taken to have ended until the applicant is notified of the review decision. Now, this is a deeming provision and it only applies for the purposes of the interim duty. But it does mean that the authority will be required to continue to accommodate under the interim duty until such time as the applicant is notified of that review decision. So it is only on the review of suitability of accommodation offered by way of a final accommodation offer or a final Part 6 offer. Next slide, please, Ben. Challenges. There is no appeal to the County Court against a refusal to provide interim accommodation under section 1881. That has always been the position, and it remains the case that there's no such appeal. The only appeal in relation to interim accommodation, as you know, is under section 204A, and that applies in relation to the discretion to provide secure accommodation pending appeal. But so far as section 1881 is concerned, the duty next to Ben, could you go to the next one? It's only by judicial review in the High Court. And legal aid is, of course, available, but with all the risks involved in pursuing judicial review as opposed to an appeal as to whether you'll actually finally get paid at the end of it. Right, that's all I've got to say. Sarah, over to you.
Hello, everyone, again. And so we have some questions which we can go through. I think most of them were addressed to Ben, but I think if I read the questions, then perhaps Ben or David can jump in as appropriate. So first of all, we've got a question from Rachel Level at Southwark Law Centre. And she says, is there any ability to stop the authority exercising the discretion to continue the relief duty, other than to JR this decision beyond 8 weeks? For example, I had a review which went on an extremely long time, and the authority had decided to do the relief duty again for an indefinite period, as it was done so inadequately the first time. But in fact, the client did not want that, as it left her at risk of receiving a notice of non-compliance, PRS offer in relief in discharge of the relief duty. We were not able to get the relief duty ended until the authority issued this decision awarding the main duty, which then automatically brought the relief duty to an end, as this was past 8 weeks. So I think, Ben, do you want to?
Yeah, sure. Yeah. I mean, I think you're right. I think it is a JR issue. That it seems to me it will usually arise where you've got a client who you think will qualify under section 193, and you want to get through to that stage as soon as possible. And the one instance when the relief duty terminates automatically is where the authority make a decision that the applicant is eligible homeless, priority need, not intentionally homeless, such that a section 193 duty will be owed whenever the relief duty comes to an end. And the Act is quite clear that happens automatically 56 days after the start of the relief duty, whether it's been complied with or not. And you've got the code that says, I think, that authorities ought to be able to issue the section 193 decision on day 57. That's what the code says. So you put those two together, then it seems to me your remedy is going to be JR, but it ought to be available if the authority is deliberately delaying. I hope that answers that one.
Can I just come in? I agree, and it's paragraph 14.16 that Ben's referring to. My experience is that many authorities, particularly London authorities, are using the relief duty to get out of addressing what they may regard as difficult questions on priority need and intentionality, and they just hope that the applicant will in effect go away because they found accommodation. And I've got 2 JRs running at the moment, which where there's been an appalling delay. But in one of the cases, it will take about 15 seconds to decide whether the applicant has a priority need and has become intentionally homeless. I mean, but they've not made a decision in 4 months. So this is something which is, I think, now becoming increasingly common.
Just before we move on to the next question, I've had an email from Lindsay in Chambers to say that issue I raised about whether you can review, whether you have a right of review of the decision to notify another authority at the relief stage based on local connection. And Lindsay says there is already a JR running. It's called R. Dogan v. Haringey, where I think permission got refused on the papers, but there's an oral permission hearing coming up on Thursday. So let's hope that sheds some light on it.
Now, Ben, I have another question for you. And this is Jay Barrero. Ben, perhaps I missed something, but I thought you suggested reasonable steps review would be those reasonable steps, not, for example, if the authority decides accommodation in the Midlands is appropriate. But you also suggested challenging location of accommodation at this review stage and before an offer. If so, do you suggest the challenge to the steps, or if so, do you suggest the challenge to the steps in those circumstances? He then says, sorry, the question has a how missing, but I'm not quite sure where the how went.
Yeah.
But I think you get the gist of that question.
Yeah, I think so. And you know, and that's the strange position. You can't review the assessment itself. You would have to judicially review if you want to challenge the assessment directly. But you can review the decision to either take or not take steps based on that assessment. And you're just going to have to look at the case you've got. You're going to have to look at the PHP that's been issued. I would have thought that usually you are going to be able to frame your challenge as an attack on the decision to take or not take steps. For example, you know, the PHP says we're going to give you a list of agents in Birmingham and you don't want to go to Birmingham. Or you put it the other way around, there's nothing in the PHP, but you ask them to help you take steps to obtain accommodation locally, and they refused based on their assessment. In both those situations, it seems to me you can challenge the decision to take or not take the step, and that gives you access to the review and the appeal. But if you can't frame it that way, and if there really isn't any other way to put it, and you're going to challenge the assessment itself, you'd be JRing, and that is going to get messy because they'll say you've got alternative remedies and so on. So probably safer to try and frame it as a challenge against the steps.
David, do you want to add anything to that, or shall I move on to the next question?
No, fine, move on, please.
Well, I have a question for both of you. Given that there is no right to a review of the needs assessment under Section 1889A, only the steps to be taken under Section 189B, do you think it's necessary to bring a JR of the needs assessment where the steps would be reasonable to meet the assessed need? E.g., if the local authority assesses that A's need is for accommodation in any city in the UK, so this is really following on from the previous question, a plan to search for accommodation in Birmingham would be reasonable to meet that need. Or do you think A can use a review of the steps under Section 189B to challenge the needs assessment on which they are based? Presumably the latter. So strategically, I think, Ben, you've probably answered
Mm.
that, but I don't know if you want to add anything to.
I think I have. I mean, I think you know, if the question is, are you going to be bound by the assessment so that will undermine your challenge to the reasonable steps? I think the answer's got to be no, because you know, there are, and I think on that slide I referenced a couple of bits of the code that draw a distinction between the issue of reasonable steps and what's in the PHP. And it seems to me, if you read the Act straightforwardly, if you disagree with the authority's decision about what steps are reasonable, you can review it, whatever is written in the assessment or the PHP. I mean, that's the way I'd read it, but I might be wrong. Who knows?
I agree with you, Ben. I mean, if you're wrong, I'm wrong too. So.
I think this is probably the last question. This is a question for you, David. So this is in relation to the part of your talk that was looking at ending the Section 188 duty through a final offer under Parts 6. And Victoria Seifert asks, is that a Section 193A offer? So hopefully you understand what that question is about.
Yes, I do. It is for the purposes of Section 193A. So that 193A defines a final accommodation offer as an offer of an assured short-hold tenancy by a private landlord, and a couple of other conditions. And the final Part 6 offer is an offer of housing through an allocation. But that's in subsections 4 and 5 of 193A. Yes, so Victoria's absolutely right about that.
And then just before we go, I note that Jane Dillon has posted one other question about, is there any chance of a challenge not to provide accommodation to a non-priority need homeless applicant in view of the pandemic and trying to rely on other legislation, i.e. Localism Act, Section 138 Local Government Act, 2B National Health Act? I mean, I think the answer to that is, come to the next seminar where Martin Westgate will tell you all about the everyone in policy.
But he's awaiting judgment, so we may have judgment by then.
We might.
Well, that was exactly what I was just about to say. So the next webinar in our sort of mini series of 3 is on the 9th of February, and that is looking at eligibility, everyone in, what is happening with that. Do we yet know under what power local authorities have been accommodating people? Well, we don't know yet, but who knows, maybe we will know by the 9th of February. So look forward to seeing you then, or you seeing us. And thank you very much for coming. Thank you.
Thank you. Bye, everyone.